Hello everybody. Thank you very much indeed for logging on to our webinar. My name is Julie Brannan. I'm Director of Education and Training at the SRA, and what I'm hoping to do over the next hour or so is talk through our consultation proposing the introduction of the Solicitors Qualifying Examination. We've got some votes embedded into the slides, so there'll be an opportunity for you to express your views on aspects of our proposals as we work through the webinar, and also you can ask questions as we go along. If you can log those as they occur to you, I will address them either during the presentation or at the end, just depending on how we're doing for timing. So moving on to the first slide. This is a preamble to what I have to say, but it is important. Technically, what we are consulting on in this consultation is purely the proposal to introduce the Common Professional Assessment. We've also raised a series of other questions, like the role of pre-qualification work experience, how we might regulate training pathways, what we might do about providing and publishing data on candidate performance and so on. But those are not aspects where we've got a specific proposal. Those are still where we've got work ongoing, and we're interested in hearing your views and giving you an opportunity to express those views. If we decide to proceed towards a common professional assessment after, in the light of views on the first consultation, then we will publish a second consultation this autumn with a proposal on those particular issues, which takes into account the views that have been expressed at this stage. But at this point, everything is open, no decisions have yet been made, all our proposals are subject to stakeholders' views, so please therefore comment. This is your opportunity to influence and shape the proposals, or indeed, if you think we shouldn't go ahead, to let us know about that too. Everything's on the table and up for grabs. So again, moving on, what's our purpose? It's very important for us to come back at all the stages through our work to ask ourselves, why is it that we're doing this? What's the objective? And we've been very clear about this. It is to uphold public confidence in the profession, both domestically and internationally, through consistent, rigorous standards. It's absolutely critical that in order for the public to have confidence in the profession, to get access to legal services, they need to be they need to trust that they will get good quality service from the profession. So this is all about ensuring standards. But at the same time, we want to provide an opportunity for greater innovation and flexibility in solicitors' training and to promote a broad, diverse profession, because we're very aware that the wider the talent pool, the higher the standards. We're already partway down our review of education and training of solicitors. We have already revised our training regulations to simplify them. We have introduced a new approach to continuing competence, which comes into force for all solicitors from the 1st of November this year. And in April last year, we published a statement of solicitor competence. So we've identified what the standards are for effective practice as a solicitor through that statement of solicitor competence. The question that we are now addressing is, how do we ensure that those competences are demonstrated at point of entry on a consistent and rigorous basis, whilst, as we said in the previous slide, encouraging innovation and flexibility of training. And what are the problems? Why do we feel that perhaps the current system is not as good as it might be, it's not effective as it might be at the moment? First issue for us is concerns that we have about the lack of comparability and consistency in legal education. I used to teach on the LPC. I'm a solicitor by background, and then for 20 years I taught on the LPC. When I started teaching on the LPC, it was 1994. The LPC had come in 1993, and at that point every single pathway to qualification had to go through the LPC. If you were a law graduate, if you were a non-law graduate, if you were a legal executive, everybody had to take the LPC, and it was very tightly prescribed. There was one particular model of LPC, a pack of materials that providers got down off the shelf, and that's what they delivered. Fast forward to where we are now, 2015, and 2016, I beg your pardon, and we have a number of different pathways. We've got on the LPC, we've got the standard LPC, we've got the accelerated LPC that can be taken over 7 months, we've got LPCs integrated within the LLB or the period of recognised training. So we've got much greater flexibility around the LPC, and that is a good thing. It's being responsive to what people needed, what the market needed for effective training for the different sectors within the market. But it does make it harder for us to compare people who come through those different courses. Even more so, we've got entirely new routes to qualification which didn't exist in 1993. We've got the Qualified Lawyers Transfer Scheme for overseas lawyers to qualify. We've got the equivalent means route, new in our 2014 regulations, which enable people to qualify if they can demonstrate that they have learning or experience which is equivalent to what we require in our training regulations. We've got the new apprenticeships which are coming on tap, which the Department of Business and Innovation of Skills introduced last September. So again, lots of new routes, lots of flexibility, a good thing, but it leaves us without a mechanism to compare that people who come through those different routes have achieved the same standard. The LPC is assessed 2 years before qualification. The Qualified Lawyers Transfer Scheme is assessed at point of qualification, and we don't know, we have no mechanism to check whether those people who come through those different routes have reached the same standards. At the same time, publications and research undertaken by other people, particularly the Higher Education Funding Council for England and the Higher Education Academy, have identified concerns about standards and quality within higher education institutions. What they say is that they don't believe that the quality assurance system necessarily demonstrates that people who come through universities have met the same standards. They identify, for example, that there has been grade inflation around the different grade boundaries. 70% of all university students these days graduate with either a first or a 2-1. That's difficult for employers. It does not give them a great deal of information on which to make their selection and recruitment decisions. But at the same time, universities have been looking at their algorithms, trying to make sure that their algorithm isn't harsher than the university down the road, and that process of reviewing their degree algorithms in that way leads to grade inflation. The research also points to weaknesses in the external examiner system for universities. Universities tend to select as their external examiners people from the same sector that they operate in. External examiners may not feel that they have the confidence to challenge some of the decisions within that are made by the institution that they are examining. So again, concerns that that system isn't as good as it might be. Closer to home, we've looked at the GDL and the LPC, and we've looked at the different providers and their pass rates, and we can see that on some courses there are pass rates of below 50%. On other courses there are pass rates of above 90%. Now that might be fine. It might be what you expect when you have different cohorts of differing ability, different teaching, and so on. But it might not be. It might be an indication of poor quality teaching in some places, and it might be an indication perhaps of exams which might be too easy or might be too difficult. That is a very, very great range, and that range of itself gives us pause for thought. We're doing some further work there. We've appointed chief external assessors to look into the different LPC courses, look at the different exams that are set, to see if we can work out in a bit more detail what is going wrong there and what is the reason for that big range in pass rates. And finally, training contracts. Over 2,000 law firms offer training contracts, and there is no mechanism to ensure that they can benchmark their standards, the standards they apply, to decide whether or not to sign off their trainees at the end of the period of recognised training. Our data shows us that only 2% of trainee solicitors fail to complete, but law firms do tell us that occasionally there are people who they encounter who they've given training contracts to, and either they're not good enough, or the law firm doesn't really know whether they've made it over the line or not. Sometimes they tell us that that is a very difficult decision. Twice law firms have said to me, well, actually we rang up the SRA to find out, and the SRA was not able to give us guidance. So we have there a picture of large groups of organisations involved in assessing trainee solicitors on the route to qualification. We've got over 100 universities involved in assessing students either at law degree stage or at GDL and LPC stage, and then we've got 2,000 universities. Really, it would be very, very surprising if they were all assessing to the same standard. Actually, we have concerns probably about each of those different stages. Moving on, we're not just concerned about comparability and a lack of consistency, we're also concerned still about the lack of flexibility. I talked a moment ago about how we have managed to inject a greater flexibility into our training requirements, and that was a good thing. But nevertheless, we still have the classic structure of tripartite training structure of academic stage, vocational stage and workplace stage. That is becoming more porous, there is more integration, but most students will come through that pathway, which I'm sure is recognisable to many of you. What that means is that we have a division, a sort of artificial division. Litigation, civil litigation, is not taught as part of the academic stage of training. So students don't get access to that and don't understand about that until very much later in their training when they come onto the LPC stage. Some universities are integrating looking at contracts and practical work around contracts into their academic consideration of case law and statutes relating to contract, but not all universities. So some students still have the experience of seeing a contract many years after they have studied contract law in an academic context. So still that very inflexible system. At the same time, it is very expensive to qualify as a solicitor. Not only do we have the £27,000 of fees that it costs to get a degree or a law degree, on top of that you've got GDL fees, and LPC fees can cost up to, and in fact now I think slightly over, £15,000. For those students who have a training contract and whose law firm sponsors them, that's easy. They get that funding. But many students will not get funding from a law firm. And those students have no access to the government student loan scheme. They have to go to the bank of mum and dad, and those mums and dads have to be quite wealthy to have a spare £15,000 down the back of the sofa, or they have to get a commercial loan on commercial rates of interest. So the cost of qualification is significant. We also know that the large law firms who buy lots of places at the LPC providers are able to negotiate discounts. So their students and those law firms will pay less for their LPC than probably the more diverse group who might not have training contracts at the start of their LPC, who will pay full whack and who will effectively be subsidising those students who are going into the elite commercial practice. We have a lack of a competitive training market. I mentioned I started teaching on the LPC in 1994, and in the 22 years since then, LPC fees have just gone inexorably up. At one stage, UWE, the University of West of England, did introduce a cheaper LPC where they charged us as little as £6,000. Now that LPC failed. I did one of these engagement events with representatives from the University of West of England, and they agreed that a large reason for that failure was because students take price as a proxy for quality. So when they saw a cheap LPC, students were worried that it was just rubbish, because there is not the objective data or information available to students to make them to choose courses which may be very, very good, even though they are cheap. So they navigate to the more expensive courses, assuming that they are better quality. We have concerns too about the period of recognised training and who obtains training contracts. We know from Law Society data that 37% of students on undergraduate law degrees are from black and minority ethnic groups, 32% of students on LPCs are from those groups, but only 24% of qualified lawyers are from those groups. So we are worried that there is an issue about who picks up those training contracts. And finally, I said a moment ago, we have got alternative routes to qualification. We are injecting more flexibility, but at the moment there is still low take-up of those alternative routes. In particular, in relation to equivalent means, we've had only, I think, about 30-odd successful applications through that particular pathway. So moving on, one final issue, final but still significant. Oh, I beg your pardon, I think I've moved on 2 slides too many. Moving one back to the slide on attainment and diversity. We're worried about attainment and diversity. We can see from our own stats that performance on the LPC and the GDL varies according to protected characteristic. The first statistic I've put up there on the slide is a significant one for us. It suggests that on the LPC, 1 in 4 black and minority ethnic students have to resit part of the course compared with fewer than 1 in 10 white students. That is a worry. That is a worrying statistic. It's not something which is special about the LPC. It applies in similar terms to the GDL and actually is a very widespread phenomenon across higher education, but it's something we should be worried about. In relation to gender, women are doing better. 64% of LPC students in 2014 were women, but we're still seeing underrepresentation of women even at entry point into the accelerated LPC, which is directed at city law firms. And it's even more surprising because women outperform men on the LPC as well as being more heavily represented. So more women than men get distinctions. Even on the accelerated LPC, more women than men get distinctions. So you might expect them to be better represented, particularly in the elite areas of practice. We don't have very much disability on social mobility, but others have commented on those, and in particular on how students who have been privately educated or have gone to Russell Group universities are disproportionately represented in the profession. So that's the picture and the position that we find ourselves in, and those are some of the concerns that we have with where we are at the moment. Why do we believe that the SQE, the Solicitors Qualifying Examination, can help address some of those concerns? First of all, and most importantly, we believe that the SQE can provide a mechanism to test the competence of all intending solicitors on a consistent and fair basis. And let's just be clear about that. Consistency is not just about a regulatory hang-up. It is also about being fair to students. It is not fair if it is easier for them to qualify in one provider rather than another provider. But it's also about protecting consumers. It's also about making sure that consumers know, and we know, that everybody who enters the profession has had their competence to practice safely, to be let loose on members of the public safely. They've had that competence assessed to a consistent and rigorous standard. We believe that the SQE would offer a better technical assessment. It would enable us to pool IT solutions and pool resources. It would enable us to keep abreast of better assessment methodologies which have been used by other professions in the medical profession, accountancy, pharmacy and so on. So those have been used in other contexts. They're widely tested, but they are not widely used in our context, and it would be an opportunity for us to get into the area of best examination practice. It would also give us objective data on providers' performance. It would give us that data that we could then share with students, and that would help drive academic quality. So, having gone through those points, question for you. Do you agree or do you disagree that the introduction of a common professional assessment for all intending solicitors could deliver these benefits? I hope you're now able to vote, and I'd ask you to cast your vote, and then we will take a look on what you think. We'll take a few moments just for those votes to come in. So I hope that you can see that on your screen now. I'll just check whether that has come up on your screen, the results of that. What we are seeing at our end is 55.6%, so 11.1% strongly agree that the SQE can provide a benefit, 55.6% agree, 22% neither agree nor disagree, and 11% strongly disagree. So a range of views, but overall people agree that this could deliver those benefits. So thank you for that. Moving on then, having had that sense of your views, which is very helpful to us, moving on then to look in a little bit more detail about the assessment model that we are proposing. What we are suggesting is that our assessment model would have a Part 1 and a Part 2. The Part 1 would assess candidates' ability to draw on sufficient knowledge to practice effectively. Legal knowledge, of course, absolutely critical for safe and effective practice as a solicitor. But what solicitors need to do, it's not just what they know, it's what they do with that. They need to be able to use that knowledge to address the issues and the problems that clients bring to them. And that's what we would assess in Part 1. We would assess it through computer-based testing. It would assess the application of legal knowledge and application of knowledge to legal processes and resolving clients' problems. We would start with the facts. We would have a series of fact scenarios. The first task for the candidates would be to categorize those facts to work out what sort of problem we are talking about. Is this a problem where the answer lies in contract, or is it a problem where the answer lies in property law? What is it? They have to categorize the nature of the problem, and then they have to work out what the best solution might be. We would embed ethical questions throughout all of this. One of the things we have learned from the LPC is that it's a very good teaching model and a very good assessment model to have unflagged, unmarked ethical questions throughout all of your assessments, so that students get used to thinking about, well, is there an ethical question here, as a matter of routine throughout their work. So we would embed ethical questions throughout all of these assessments. We would put them into different, there'll be a number of different modules. So we would bundle together different groups of subjects which could be taken together. But the knowledge that we would test would, broadly speaking, correspond to the 7 foundation subjects which are taught in the LLB or the GDL, and the core subjects of civil criminal litigation, probate, property, and business law and practice, which are taught on the LPC. So that's what the first part would be. And then we say at the moment we would suggest candidates must pass that before they attempt Part 2. Part 2 concentrates on the skills. So here again, although knowledge is fundamental to safe practice as a solicitor, so are the core lawyer's skills. We've divided them into 2 sets, written skills and oral skills. So the written skills are writing, drafting and legal research. We might put those together in a case study assessment where candidates have to undertake legal research. They then have to produce a piece of writing and a piece of drafting on their findings. So that would be one exercise, one test. Then we would test the oral skills through separately. The oral skills of interviewing and advising, advocacy or oral presentation and negotiation. Those would be tested separately, and we would test the written skills perhaps through computer testing, but the oral skills would be tested through role plays with a standardized client to offer that degree of consistency in the assessment. So these would be through tasks which would simulate the real demands of practice. Many of you may be familiar with that sort of testing through the legal practice course, but this we would put not at LPC level, we would put this at point of qualification level. So if you like, we would be testing whether people had gone, who at the moment would go through the training contract stage, we would be testing whether they had acquired through that experience of the workplace the real skills in order to be let loose on members of the public and go and do a real interview or a real piece of writing on a qualified solicitor basis. Again, we'd embed or unflagged ethical questions throughout all of this, and again, we would modularize these assessments so they could be taken separately. Now, one of the things that we have given some thought to is what contexts should we assess these skills in? And it's a question that we have asked in the consultation paper. What we are proposing at the moment is that we would focus this in the main on the reserved activities, those activities which solicitors are entitled to practice by virtue of their title, by virtue of their qualification, which others are not entitled to practice. So civil litigation, criminal litigation, property law and practice, wills and probate, law of organisations. We recognise that not everybody gains those sorts of experience, that sort of experience in the workplace, and we envisage that in order to be able to take these assessments, it would be very helpful for candidates to have workplace experience so they have seen for real, firsthand, what it looks like to do a client interview, to write a letter, to do a piece of advocacy or an oral presentation. So what we have suggested at the moment is that skills might be assessed in 3 of those 5 contexts, including contentious and non-contentious elements. And you can see from that there is a similarity with our current requirements for the period of recognised training, and that's deliberate. So I've got a couple of questions for you on all of this. I know there's a lot of information to take in on that, but a couple of questions. So moving on to the first question, looking at that model as a whole, do you think that that model could provide an effective test of the competences needed to be a solicitor? So we'd be interested in your views. I hope you're now able to see that and vote on that question, and we'll see how things come on and what comes through on that. So I hope that you're able to see that and to get voting. So I think we now have some results which you may or may not be able to see, but the results that I can see on my screen are that 9.5% of you strongly agree with that as an outline assessment model, 42.9% agree, 28.6% neither agree nor disagree, 14.3% disagree, and 4.8% strongly disagree. So again, a range of views. That's very interesting to us. Overall positive, but we recognise that there are a range of views in that. Some of you who voted, if you want to perhaps post something for us just explaining why you agreed or why you disagreed, what your reservations were, that would be very interesting for us to hear. So that's very helpful. Thank you very much for that. Moving on straight away to another question. So our next question is specifically around the point that I was talking to you about in relation to the assessment contexts. What do you think about the assessment contexts? I described what we have proposed at the moment in our consultation. We've said let's focus the assessment contexts for the Part 2 around the reserved activities and the law of organisations. But we could do something broader. We could spread those out so that we offer a wider range of choice. We could say you can choose to register for an assessment in the context of employment law or family law. We could focus the assessments on the reserved activities but recognise that there is a difference between domestic conveyancing and commercial property, and we could give people a choice within that broad range of what broadly is a reserved activity. That has many positives to it. It means that people get more choice. It means that it's easier for them to align their work experience with the assessment that they have to take. But obviously it comes at some costs. It makes the assessment more complicated. And therefore, because it's more complicated, that would drive expense. And if you have more choices, increased choice, of course, it makes it harder to make sure that people are all being assessed to the same consistent standards. So, like many of these issues, pros and cons. We'd be very interested in your views. I hope you can see voting buttons on your screens again. So, perhaps we could, if you could vote, and we'll see what your views are on this. Well, this is a very interesting response. We've had exactly 50-50. So we've had 50% who think we should focus on the reserved activities and 50% who think we should offer a broader range of contexts. Very interesting. I have to say that is in line with what we are picking up from other engagements events that we have had. There doesn't seem to be a consensus of views on this. I think this is going to be quite an important thing for us to think about in more detail. But it's very interesting that you were split absolutely down the middle. So, can I pick up at this point on a few questions? So, somebody has said, with regard to the assessments, this is Marwa Tawofi, so thank you for your question. With regard to the assessments, do candidates book them individually or through an organisation? Very, very good question, and thank you for raising that. I should have made that clearer as I was going through. What we are envisaging is that we would appoint an assessment organisation, an expert organisation who would offer this assessment to all comers. We're thinking that we would probably have at least one organisation, one lead organisation. They might want to subcontract them. We recognise there may be organisations who are expert at online assessment and other organisations who are expert at legal assessment. So they may want to form a consortium, but we would engage with a single umbrella organisation or lead consortium provider. Now, they would then offer that to all everybody who wanted to qualify as a solicitor. And our thinking would be that everyone, whether they're overseas lawyers, whether they are people coming through the domestic route to qualification, everybody would take that assessment. Now, somebody else has asked, Tamara Karbi, thank you for your question. Have you currently decided a cost for the new assessment or what it is likely to be? Very good question, very important question. We have done some modelling around this, but ultimately it would be something that we would need to negotiate with the assessment organisation, and because it's commercially sensitive and because we don't want to set expectations about where that cost might be and those quotes might come in at, we don't want to go public with our modelling. But let's be clear, if we're going to go on to talk about how we might regulate pathways in a moment, but if we were to be less prescriptive about the qualifications and the pathways that people followed, that might enable us to deliver some savings. If we said people didn't have to take an LPC, people didn't have to take a PSC, whilst there might need to be some training for the Solicitors Qualifying Examination, and whilst there might be some cost associated, I'm sure there would be cost associated with the exam itself, that gives us savings of up to about £16,500. So there's a lot of saving there that could come through changes to the current system, and we would very much hope that the new system would not be as expensive as that. We would hope that the new training courses wouldn't be as expensive, and we would certainly be shocked if the assessment itself cost anything like that. We've got a question that's come in from an LPC graduate, Konstantin Shestakovsky. I hope I've pronounced your name properly, Konstantin. Thank you for your question. Konstantin has asked about whether existing LPC students would be able to get exemptions from these proposals. We've put some information on our website about exemptions, and what we have said is that if and when we introduced the SQE, if people were part way through the current qualification, they would get recognition for the stage that they had got to. So nobody would have to go back to the beginning and start all over again. If you had got to LPC stage or training contract stage, you could complete that, and you would get credit for what you had done, but you would be able to choose. So you'd have a wider range of options. You could decide whether you wanted to go down the current pathway, or if it suited your circumstances better, you could choose to go down the new pathway. If you, at that stage, you were on an LLB, so you're at the academic stage of training, then you could complete your LLB. You would be given credit for what you had done on that course, but then when you moved to the next stage of training, you would have to move on to the new system. So that's what we were proposing on that. I think, having taken some questions, I will move on now to the next slide, and I think there are other questions too that we can come back to if we've got time at the end of this webinar. But we've got other interesting and important things on which we're very keen to get your views. One of which is pre-qualification work experience. As I said at the beginning of this presentation, all we are technically consulting on at the moment is the introduction of the SQE. What we are not saying or not proposing is a particular approach to how we specify what the way people prepare themselves for the SQE. I have said that we do think that pre-qualification work experience and work experience would be very important as part of your preparation for the Part 2, as part of people's preparation for the Part 2 assessment. But what about the existing training contract? Are we going to still have a requirement that everybody has to do a training contract? We have said in our consultation that we are likely to want to recognise a requirement for some form of pre-qualification work experience in addition, over and above the SQE. And the reason for that is simply that we recognise the tremendous value that comes from going into the workplace, learning from experts, learning from professionals who are doing this job day in, day out. It's how I learnt to be a solicitor. It's what lots of people say they value tremendously from their training, and there's lots of research in the context of qualifying as a solicitor and other professions and other jobs about the value of workplace learning. So we think that we should have some requirement for that, but we also recognise that it may be desirable to recognise a wider range of experience. I talked earlier about how there are some issues about who it is that gets a training contract. I talked to somebody in one of my engagement events who told me about how they had gone to a very good law firm. They'd got 2 years experience under their belt as a paralegal. Then they got a training contract at that law firm, but they had to wait 2 years for the training contract to start, so they spent another 2 years as a paralegal. So they spent 4 years as a paralegal, and then they had to do their 2 years training contract on top of that. And I said to them, well, at the end of your 4 years as a paralegal, were you doing the work of a trainee? And they said to me, no, I wasn't. I was doing the work of a 2-year qualified solicitor. So there is something that we need to do to be, I think, a bit more flexible about recognising some of the very valuable experience that can come from work as a paralegal. So can we have greater flexibility? If so, how? Do we need to continue to specify a particular length of time? If so, how much and how long should it be? Can we be more flexible about the number of organisations where this sort of experience is obtained? Could we, for example, recognise experience that students get in law clinics at university? Universities tell us that they increasingly offer this experience to their students and that they recognise how it enhances their performance even in the academic stage of training. Can we recognise that? Can we encourage that by recognising that sort of experience? And can we encourage people to perhaps to go around and gain experience in a wide range of employers, recognising that that might actually be a richer experience than experience gained in a single employment context? Can we get greater use of guidance rather than prescriptive training requirements? In our new approach to continuing competence, we've got a toolkit of guidance rather than having rules. Could we do something like that, communicating and being clear to people about what good training looks like? And another point, what do we do about workplace assessment as opposed to workplace experience? Should we assess people in the training contract? Should employers assess people in their workplace experience, or is it good enough to have an expectation about what valuable work experience might look like and then rely on the SQE? Lots and lots of different questions wrapped up in all of that. So very interested in your views. Moving on to the next question. Do you agree or do you disagree that we should continue to require some form of pre-qualification workplace experience? Again, we'd be very interested in your views on this and any other observations that you might have around workplace experience. Please do send through your questions. So I hope you can see that and you can vote. I'll be interested to see what results come through. So here we have a very, very strong consensus. We have 77.8% of respondents saying that they strongly agree that we should retain some form of pre-qualification work experience. That's a very clear message. Thank you for that. And then a further 13.9% saying they agree. Small number, 2.8% saying neither agree nor disagree, and 5.6% saying they disagreed. So a very strong response on that. Be very interested if you want to ping some questions through about the other questions that I explored with you. What about workplace assessment as opposed to experience? Would you feel able, if you're an employer, to assess your trainees? Do you think that that is necessary? How might we set about that? How can we avoid that assessment getting into all the difficulties about inconsistency and burdens around bureaucracy and compiling portfolios and assessing portfolios while still having some benefit in terms of assessment? I'd be interested in any questions that come through on that. I don't know if we've had anything coming through. Nothing yet, so no questions yet, but please do, if anything occurs to you, please do send things through. So moving on, we have begun to model what some training might look like, some of this looks pretty similar to where we are at the moment. We think that new and even more innovative pathways may emerge. So we have a number of options around how we might regulate training, and we'll come on to a slide around that at the moment. But if we were no longer to require people to go through the LLB or GDL and LPC and training contract route, if we were to liberalise our requirements around that, what might emerge? Well, the first thing to say is that although we are assessing an assessment, and that although it might be taken over time, that is a snapshot, we still believe that it will take likely a number of years to obtain the necessary competences and knowledge to prepare yourself to take that assessment. So one option might be through the government-funded apprenticeship, which is coming on tap. That is 5 to 6 years long. A law degree, we still think that many solicitors would choose to qualify through a law degree. 50% of the population these days, or approaching 50%, are going to universities. Will solicitors continue to be drawn predominantly from that group? Of course they will. So we believe that even if we were not to require a law degree, many solicitors would continue to go to university for the value that gives them, for the valuable experience they have. But we believe that there is opportunity for universities to integrate into their law degree elements of preparation for the SQE, including those elements which at the moment are taught through the LPC. That could mean that they get through all of Part 1 of the SQE during their degree. That would then mean, depending on how long, if and how long we specified for the training contract stage, that it might take them 4 to 5 years to qualify, including that workplace training which might be integrated into preparation for the SQE. Certainly some universities that we have spoken to, including some Russell Group universities, are exploring that option at the moment. They're interested in how this might enable them to innovate and reinvigorate their law teaching. But other universities that we have spoken to are absolutely upfront that from their point of view, they are legal academics. That is what they know best. That is what they are able to teach to their students, and they don't think that they would integrate the Part 1 of the SQE into their law degree. For them, they would continue to offer a traditional degree as they do at the moment, and so students who choose those degrees would then need to take some form of SQE preparation course, which might be shorter than the current LPC because we wouldn't be requiring the LPC electives to be taught, and they could take that course which would prepare them to sit Part 1 of the SQE. And then those students would go off and do some form of work experience with the Part 2 of the SQE integrated into it. So a number of options there. Moving on, further options still. The non-law degree route, in other words, what at the moment is the GDL route, we do think that there will continue to be a market for non-law graduates who wish to qualify as solicitors. Students will want to do that, and we anticipate that employers will want to tap into that expertise and that pool of talent. So again, we've talked to universities about this, and they see that they could very easily integrate preparation for the SQE Part 1 into their GDL and LPC, what at the moment are their GDL and LPC syllabuses, so into something that would be a new course, but that could take a non-law graduate through those areas and prepare them to sit for the SQE Part 1. Another option is what we refer to commonly as the sandwich degree, so an integrated degree where universities might offer work experience as part of an integrated package, which includes preparation of the Part 1 and the Part 2 of the SQE. a very attractive option. And again, there are already some developments here. We've got Queen Mary College London working with Reed Smith to offer this sort of package, except their frustration is that they can't at the moment offer a formal training contract as part of their work, their degree. So this might enable universities to do that, to integrate a formal, the workplace experience that's required for training as a solicitor into their integrated law degree, work closer with the profession, and gain those benefits that universities tell us they see from students having exposure to professional experience as part of their training. So those are some of the options that we could see emerging through this process. But it depends on how we are to regulate training, and there are a number of options. We could do what we do at the moment. We could specify the design and content of training courses and say to students and say to providers, this is what you must deliver, and students, these are the courses that you have to go through. And I think from the Law Society's response to our consultation on the SQE, while they welcome the SQE in principle, they think that we should continue to do that to specify the design and content of training programs. That would limit flexibility. It would constrain the development of some of these new options, new flexibilities that are coming through. So alternatives could be that we could kite mark or approve training programs, so providers could say to us, we think we've got this nice new innovative model that we've come up with, we think that it is a good way of training solicitors, would you kite mark it? Would you say we think that that is a good process? So we could do that. Again, there are pros and cons. The risk for us is that when we kite mark something, like we used to do for CPD, we don't know very much about its actual quality. So the risk is that we are kite marking something, but we don't really know enough about it to say, hand on heart to students, whether it's actually a good method of training. We could publish data on provider performance. We could say, actually, we know that the candidates who have come through this particular education training provider perform this well on the SQE. The pass rates for provider X are whatever they are. And that would give us a grip on the quality of the preparatory training for the SQE, and it would give students information to guide their choices about training providers. So that does have that advantage. We could also introduce eligibility requirements to sit the SQE. So we could say you've got to have particular qualifications as a prerequisite in order to be eligible to take the SQE. So lots of different thoughts about that. And that takes us to our next question. Again, what we'd like here is we'd like you to choose what you think is the best answer. So which of these do you think these options set out on the slide would best ensure quality of training without restricting flexibility? Just waiting for the results to come through. Here we go. So, well, here we have a split. We do have actually pretty much a 50-50 split. 50% think that we should specify the design and content of training programs. 15% think that we should approve or kite mark training, and 35% think we should introduce eligibility requirements. Now, I don't know whether something has gone wrong with our poll, because we don't have any people voting for data. So I don't know whether that's something that's gone wrong with the poll there, or whether actually that is your view, that nobody who's listening in thinks that we should use data to drive performance. So that's very interesting, and thank you very much for your views on that. Again, anybody who wants to comment on that, I'd be very interested in any comments that you want to post. So that takes us through the slides, most of our slides. I've got a final slide on timetable and next steps. I don't know if we've got any further questions that we might want to pick up on. Somebody has said, this is a very interesting presentation. This is from Aviram Gavish. Thank you very much. Aviram says, may I receive a copy of the presentation? Yes, I think these are going to be available on our website, and I think the webinar also is available on our website after we have broadcast it, so you will be able to get to it. Somebody else, Kath Kinch, has said, will there be no requirement to do financial and business skills? A good question, Kath, thank you for that. The assessment assesses the competencies set out in the competence statement, and in the competence statement we have included elements about financial awareness. So I think what we have said in that is that we do expect that all solicitors need to have a financial awareness of the context in which they work, and they also need to have an awareness of the commercial and financial circumstances of their client. So we would expect that sort of competence would be embedded into our assessment. So thank you for that, a helpful and useful question. So I think that's it. I think that picks up pretty much the questions that people have raised. So moving on then to the final slide, timetable and next steps. I've already explained that our approach to consultation is a staged consultation. So this is our first consultation. It closes on the 4th of March 2016. Most important message is please do put in a response to your consultation. We will be going through all responses. We will be taking all views into account. So please do get back to us with your thoughts and comments on this. Subject to the outcome of that consultation, if we decide to proceed to go ahead with the SQE, there will then be a further consultation in the second half of 2016 on some of the other issues that we have explored with you today: pre-qualification work experience, eligibility requirements, how we regulate preparatory training for the SQE. Our overall timetable is that we need to publish something called an assessment framework document. That document will set out the detail of what the SQE, if we introduce it, would need to cover. It would answer the sort of questions that Kath has just come up with. What is it we're examining? Which assessment instruments are we going to examine that in? Where are we going to assess them? What's the weighting? And so on. We would hope to publish that either December 2016. It might move over to December 2017. The assessment itself would come in not before September 2018. That is a not before date. We have asked a question about that in the consultation. Again, please get back to us with your views. And the final cut-off date for admission would be that everybody would be expected to move to the new system at a long start date of 2025 to 26. But we would have transitional provisions for people to move to the new approach before then. Of course, all of that is subject to the point that no decisions have been made. We will review all the consultation responses, and that would go to the SRA board. We hope in about June this year for the SRA board to make a decision on this. So I think that is it. Thank you very much indeed for listening. Thank you for voting. Very, very helpful feedback. And thank you to those of you who have raised questions. If you've got further questions, I think we've got a mechanism on our website for you to contact us. Very happy to deal with your questions or to bear in mind your observations. Have a look at our Training for Tomorrow website. Lots of important information there. We're tweeting, we're blogging, so it's live, and this video will be up there, or this webinar will be up there, and other videos are on the website. So thank you very much, everybody, and have a good afternoon.